So, Darwall and Dartmoor, what can I say that doesn't sound like sour grapes? I'm only going to make one brief point, and it's to do with what might have been an interesting opportunity to hear from the Supreme Court about one of the features of the law of this country, which is quite distinctive. That is that, on the whole, we don't criminalise trespass in this country. That has some implications, and I do wonder whether they are really adventitious. I think perhaps they are systemic. I think the implications are deliberate. I think at some quite profound level, over the centuries, the absence of parliamentary intervention to criminalise trespass reflects an understanding of liberty, how liberty works, and Dartmoor is perhaps an exemplar of how liberty conventionally works in this country, or an aspect of it. It's like this. On Dartmoor, apart from the 1982 Act, anyone in this country was free to enter on the commons for recreational purposes, and as and when they provoked a reaction by the landowner, there and then, in the moment, they would have to negotiate a solution. That might be as simple as hearing from the landowner, look, you've put this monstrous, colossal purple tent in the middle of a beauty spot. Please pick it up and move it over there behind that outcrop of rocks where it's not going to blight my view. It's not going to blight the outlook for anyone else using Dartmoor. It might have been as simple as that. In the end, of course, in that sort of hypothetical interaction, there could be no doubt about whose will would have to prevail. It would be the landowner, because the landowner is the landowner with the right to kick off trespassers. But under this, what I'm going to call the model of liberty, the liberty model, there is that opportunity for a bespoke solution negotiated between human beings right there on the spot. Compare that with the rights model. With the rights model, of course, you find that the regulatory intervention is loaded with caveats. It's loaded with qualifiers. So you can do your recreation on Dartmoor, but X, Y, Z. You mustn't damage the soil. You mustn't light fires and all the rest of it. Who is to mediate that in the moment? Take the case of the person whose presence on Dartmoor is regarded by the landowner as having caused unreasonable damage, something that the regulatory regime doesn't contemplate. But of course, this is disputed by the camper, for example. In that interaction there and then, who mediates, who adjudicates on that question? It's not justiciable there and then. So something is gained when liberties are converted into rights, when they undergo that upgrade. But something also is lost. And the thing that is lost is that opportunity at the human level to negotiate a micro solution to a micro problem. I think if you immerse yourself in the mindset of the framers of the 1982 legislation, it's hard to escape the consequence that they were thinking in terms that would translate quite easily into what I've called the liberty model versus the rights model. And the 1982 Act, I think on one legitimate view, was legislated against that understanding. And what Parliament came up with was a hybrid. For the most part, the liberty model was preserved. It was preserved for all recreational activities. People were to be as free as before to go on to Dartmoor and do whatever they liked, subject to intervention by the landowners. But out of that, there were carved two exceptions. Initially, the exception was limited to people who wanted to walk on Dartmoor, and you can understand why that might be so. You can understand why Parliament might have thought, well, this is going to be a fleeting, transient presence of people walking across this vast landscape. What possible harm could there be with that? Over time, and in fact the reason why the first draft of the bill failed was that lobbying from another group of transient users on Dartmoor prevented the first bill from passing. These were the horse riders. They said, well, we want to get onto Dartmoor as well. So the first bill failed. The second bill passed. On top of the walkers having a right to walk across Dartmoor, now also the horse riders had a right to walk across Dartmoor as well. But those in the mindset, I have to say, I think this is pretty apparent from the way the Act developed in Parliament. The walkers and the riders were the only users whose use of Dartmoor came to be upgraded from the liberty model to the rights model. And as I said, one can understand why that might have been thought to be a sensible arrangement. And I do wonder whether an opportunity was missed for the Supreme Court to say something about the importance and the value that is part and parcel of what I've called the liberty model. The value of human interaction, face-to-face, negotiation, discussion, on the spot. It's useful in society to have that bedrock of expectation that we will sometimes talk to each other, see if we can find sensible solutions to what typically are going to be pretty small problems. Anyway, that clearly didn't tickle their lordships' imaginations. I don't think I'm going to say more about Darwall and Dartmoor.